Well, good morning, everyone, and welcome to the Tuesday, September 21st, Washington County Board of Commissioners meeting. Clerk Moss, announcement and roll call, please.
Thank you, Madam Chair. The Washington County Board of Commissioners also meeting as the Board of Directors for Clean Water Services and all other county service districts is now meeting in this regular session. September 21st, 2021. Commissioner Willie?
Here.
Commissioner Fye?
Here.
Vice Chair Treese?
Here.
Chair Harrington?
Here.
And Commissioner Rogers is joining right now.
Commissioner Rogers, are you there?
Sorry, I kept trying and it wouldn't let me in, so I'm here.
All righty. Terrific. We have just a couple of updates to the agenda today. Item 15 on the consent agenda will be moved to the action agenda, so we'll have a total of 3 items there. Then one of the public hearing items, item 1, has been pulled from the agenda. All right, next we'll move to oral communications. Clerk Moss, what do you have for us today?
Next up, Madam Chair, we have Charlie White. Charlie, can you hear us? Charlie, can you unmute?
Yes.
Right.
Can you hear me?
Yes, we can. Please go ahead for up to 2 minutes.
Thank you. I'd like to start with a prayer. Dear beloved Creator of all that is, we acknowledge the unlimited diversity of your creation, of which we are a significant part. Our body, mind, spirit, soul presence is imbued with your wisdom and intelligence at every turn, but only when our will is thy will. Because we are of you, created by you, because of you, beloved Creator, we honor you by taking responsibility for ourselves. We honor you by our actions that honors all life and the free will of others and serves the divinity and humanity, the perfection of your creation, and so it is. I now refer to the Oregon Constitution, to which I am assuming you've been all oathed. So in Article 1, Section 1, it reads, natural rights inherent in people. We declare that all men, when they form a social compact, are equal in right, that all powers inherent in the people, and all free governments are founded on their authority and instituted for their peace, safety, and happiness, and they have all times the right to alter, reform, or abolish the government in such manner as they may think proper. As a postgraduate, a professional, my career, and a mother of 3 and a grandmother of 11 and a great-grandmother, I am and have been fully engaged in my community and in life. I consider myself highly qualified to make health choices for myself and those I care for. I wrote your commission a letter last month regarding your enforcement of Kate Brown's mask mandates and vaccines. Whether you are in the medical field or not, mingling health and wellness decisions with politics is why we are even in this pandemic hysteria, which is totally media, pharmaceutical, politically driven. It is a campaign. It is a depopulation and transhumanist agenda, and I urge you to see how it is meant to harm and undermine the essence of being human, socially, economically, emotionally, and psychologically. Unless each one of you does some deep dives into how this has all come about, how it violates our unalienable rights, terraforms our social and environmental fabric, and how it was all created by some very evil intent years in advance. You will continue to make poor policy and do real harm to the people who put you in these chairs.
Thank you.
Thank you.
Thank you. Next up, Madam Chair, we have Cynthia. Cynthia, can you hear us?
I can. Can you hear me?
We can. Please go ahead for up to 2 minutes.
Okay. My name is Cynthia, and good morning. And I would like to talk about the difference between 2 words, de jure and de facto. The word de jure is a Latin phrase used to describe something that exists according to law or right by law, conforming to the law, but it's not necessarily recognized as fact. This was our constitutional Republican form of government before 1861. De facto, on the other hand, is established as existing in fact, whether with lawful authority or not, exercising power as if legally constituted, bringing us into color of law. Color of law refers to an act done under the appearance of legal authorization when in fact no such right exists. It applies when a person is acting under real or apparent government authority. This type of unlawfulness and governance began to surface in our nation around 1861. This brings me to the IRS, which comes out of the incorporated version of our nation's Constitution. The IRS traces its roots back to the United States Civil War. In 1862, President Lincoln asked Congress to create a position called Commissioner of Internal Revenue. At the same time, President Lincoln enacted an income tax to pay for our war expenses. The IRS is owned and operated outside of our nation, as is the Federal Reserve, a private bank that lends our government money. The IRS is responsible for the nonprofit 501c3 organizations which exist today, which also the churches fall under, pushing God out and letting the government in by using control and fear of losing their tax-free status if not in compliance. I ask the Washington Board of Commissioners to return to a constitutional Republican form of government, one that doesn't push out how our Constitution and how our nation actually began by pushing God out of the center of everything that
Right.
is done.
Thank you, Ms.
Thank you,
Palmatier.
Cynthia.
Thank you.
All right. Next up, Madam Chair, we have Ron Vrooman. Ron, can you hear us? Can you unmute, Ron? There you
Yeah,
go.
can you hear me?
Yes, we can. Please go ahead for up to 2 minutes.
All power is inherent in the people. We have formed a grand jury pool and a trial jury pool of Oregonians, all expatriated from the de facto as non-U.S. citizens. That was last winter. We are no longer deceived. Last spring, we brought forth lawful presentments in lieu of indictments to 38 de facto prosecutors and true bills to the de jure trial against Kate Brown, Ron Wyden, Jeff Merkley, and Suzanne Bonamici. Then we implemented Article 3, Amendment 7 of the United States of America's Constitution, circa 1859, the one Supreme Court claiming original jurisdictions whose jury verdict is without appeal. First, we arraigned the four of them in public at the Capitol, and the following week we tried and convicted them, all guilty as oath breakers, without honor, and may not hold a position of trust, and guilty of due process violations, 18 U.S.C. 3571, a $250K penalty for each incident to each Jural Assembly member. We are the Oregon Statewide Jural Assembly, www.orsja.org. We meet on Skype Mondays at 7 p.m. Our function is to return Oregon to a constitutional Republican form of government through a grand jury process. There really is an active conspiracy. The industrial, military, judicial, legislative, executive, banker, bar, royalist, communist, Muslim, Georgia Guidestone complex.
Thank you, Mr. Roman.
Thank you, Ms. Vrooman. So, Madam Chair, that concludes this part of the public testimony. And please note for all of the members that have signed up to testify under the public hearing, when we get to that, I will call your name in the order that you came about. So thank you, Madam Chair.
The next thing on our agenda is public communication, our second opportunity of that. Clerk Moss, I don't know if we have the same people signed up.
Yes, Madam Chair, we have one that wasn't online for the 2 minutes, so we'll allow him at the 5 minutes, and this will be the only one that we're aware of. Mr. Bailets, can you hear us? Can you unmute, Mark?
Oh, I thought you said by Bailets.
Yeah.
Yes, I am unmuted.
All right, please go ahead for up to 5 minutes.
Washington County Commissioners, please return to a constitutional form of government. We have been lied to and placed into a benevolent predatory form of martial law federally since March 1861 through one form of martial law or another. This is until we know that Portland is a subdivision of Multnomah County, is a subdivision of the United States of Oregon, is a subdivision of the defunct United States Incorporated. That is not a constitutional form of government, we are guaranteed. The encroachment upon our unalienable rights has caused the people, like the proverbial frog sitting in a pan of water being heated, to jump out and do something about the dilemma rather than become cooked. Regarding the Second Amendment, public servants, e.g. civil servants, e.g. government servants, do not have the authority to infringe on the right of the people on Oregon to conceal carry. We, the people, already have the Second Amendment. No state shall convert a liberty into a license and charge a fee therefore. Murdoch versus Pennsylvania, 319 U.S. 105. It applies to concealed carry licensing fees charged by the local sheriff. If the state converts a right into a privilege, the citizen can ignore the license fee and engage in the right with impunity. Shuttlesworth versus City of Birmingham, Alabama, 373 U.S. 262. However, the judges, courts, juries will convict anyway. Knowingly obstructing the administration of justice in and of itself is malfeasance in public office. Whether it is done with malice of forethought or unwittingly out of ignorance, it is to thwart the will of the people. It is to promote a hidden agenda that is wholly antithetical and diametrically opposed to the Constitution and Bill of Rights. Whenever public servants falsely view themselves as governing officials, backed by bar attorneys and corrupt activist judges, the more damage is done to the republic. I reiterate, knowingly obstructing the administration of justice is of and in itself malfeasance of public office. Further, in addition, this applies to individuals and organizations of individuals receiving hidden compensation that buys their disloyalty to the cause of we the people, the Constitution, the Bill of Rights. I yield.
Thank you, Mark. And Madam Chair, that concludes the public testimony for today.